But number one is you cannot get paid transaction-based compensation because that's the hallmark of broker-dealer. So again, you and I are legitimate co-sponsors. We're doing all the work. We're not getting paid because we're raising money. We're getting paid because we found a deal. We're putting this deal together and we're going to make a lot of money for our investors. Number two, we have to have substantial duties. Well, yeah, if you and I are doing it, we're doing all the work. So that's not a problem. And then our primary role needs to be doing those substantial duties, which is true. We're doing all the work. Yeah, we have to raise capital, but that's one of 100 things we do. And we do everything else, right? So that's why the co-GP, me and you, not a problem. I fit into the issue exemption. The next layer out, though, which is really the problem that we're having now, is that people are just literally trying to go become a co-GP, like the third or fourth or fifth, or sometimes the 12th or the 15th co-GP. Right. And really, they're primarily there to raise the capital.
Hi, Adam Gower here, founder of GowerCrowd.com and host of the Real Estate Reality Show at youtube.com/GowerCrowd. Welcome to today's episode. Well, I've got the great pleasure of introducing you today to Mauricio Rauld, who is a securities attorney specializing in real estate syndications. And oh my goodness me, I had a list of like 20 different things I wanted to ask him today, based on the comments that he puts out on LinkedIn. And I think we got through 3 of them, basically. He's a fascinating fellow, and we took some deep dives on some very, very important topics that if you are a syndicator, you absolutely, positively need to pay attention to, right? So it's very important, practical podcast for syndicators today. If you're an investor, it's also a value because you want to be sure that your syndicators, whoever you're investing in, are playing by the rules. Oh my goodness me. In the words, I can't remember if we actually said this, but Warren Buffett, when the tide goes out, said, is credited to saying, when the tide goes out, that's when you can tell when everybody, or who's swimming naked. That's exactly what Mauricio gets into in details today. What exactly have people been getting up to? What should you be looking for? If you want to know more about Mauricio, please go to the podcast page at GowerCrowd.com, and I'll include a bunch of links there. And of course, while you're there, subscribe to our newsletter. It's totally free. It goes out every Wednesday. You can always unsubscribe, right? Educational content there in your inbox once a week. All right, that's it. Here he is, Mauricio Rauld, Esquire, talking about some of the most important things to keep in mind in real estate syndication at any time, but particularly today. Here he is. Mauricio, it's good to see you. Finally, we catch up to do a podcast. I'm very happy. So here's what I've got. I've got a list up. You are an amazing poster on LinkedIn. And so what I've done is I've gone into your feed. I recommend anybody to do this. Go into your feed, and actually every single post, I'm going to totally date this because these are posts that I've just looked at, are high value, interesting posts. So let's go through some of them because the topics are very interesting. And this was the first one here. This is, as of last year, 70% of all syndicators had 3 years or less of experience. So my question is, where do you get that statistic, first of all?
That's a fair question. You know, that one, I was just hearing it all over the place last year. And so I don't have a solid source for you. It was just something that was pretty prominent out there, but I recognize that just because it's on the internet is not true. No, but that does not surprise me. It's not like a crazy stat because, and it really is meant to drill down the point that there's just a lot of people, primarily because of this wave. I feel like over the last, 2 or 3 years, there's just been an explosion of, people quote unquote coaching or doing these programs, and they're just literally bringing in people who have no idea what they're doing and teaching them in a 12-week program. And then suddenly the next thing you know, they're out there and they're trying to raise money. And so there's a lot of inexperienced people out there, which I think is part of the problem and part of the reason we're having a lot of issues now, because when everything's going, everything's just increasing 10% a year and, everything's going great, then you can throw a dart at a thing and you're a genius, right? But that all stopped in the middle of 2021, right? It's been about almost 3 years now, 2.5 years. So the most, I think, the more, not to say some of the experienced ones aren't having problems, but a lot of the inexperienced ones, they just didn't even know what a rate cap was, or they just didn't really understand that stuff. And I know it's a little bit off topic, but it really goes back to one of my biggest pet peeves right now, which is, a true syndicator, like somebody who's syndicates, really, they have a skill set. They're in real estate. They are an operator. They buy multifamily or they buy real estate, and they're good at it. And they're so good at it, they've made a bunch of money. And so now they're like, hey, let me expand my network. Let me bring in my friends. Let me raise more capital so I can do bigger and bigger deals. Because if I can do it at this scale, if I do it at 10x scale, I'm just going to make 10x money. Let me bring my friends along. Let me help other people. But what's been happening over the last 2 or 3 years is people are just raising money for the purpose of raising money. They don't really know anything. They're just trying to learn the skill of raising capital, but they're not going through a licensing process. They're not actually going and studying how to raise capital, getting a license and doing it legally. I'm just going to go raise a bunch of money and give it to Adam over here who's got a property, and I know
Okay,
about multifamily.
right. So that's really interesting. So that actually dovetails into another question: licensing. So what are the different flavors of capital raisers out there? There's the GP, then there's the so-called co-GP, there's the finder, there's like a whole range. What are they, and what's legal and what's not?
Yeah. So it's generally speaking, if you're raising money for your own account, right? Like if it's just you, like Adam goes out and saying, I want to go buy this multifamily property, and I'm going to go raise a bunch of money. Then even though you've set up an LLC, obviously for asset protection purposes and business purposes, the law looks at you're basically raising money for yourself, for your own account, right? So that you don't need any license whatsoever. You only need a license when you're raising money for other people or other people's account. And so what most people don't think through is that even if you're like if you and I have a deal, right? So you and Adam, you and I are partners and we're raising money. We're technically raising money for our syndication entity, right? That's buying the property. So even we are not really part of the syndication. We are the manager of the syndication, or what's called an associated person. And so when that happens, the rule is you have to either have a license, because I'm raising money for others. So I'm going to have a broker dealer license, because that's the license you generally need, or have a representative under a broker dealer, or I have to find an exemption. And 90% or all the legitimate sponsors out there, syndicators, fall inside that exemption, which is why nobody that's doing syndications properly needs a license. It's because they fall under this exemption that we call an issuer exemption.
Right.
A terrible name because it's not really the issuer, but that's what we generally call it, an issuer exemption. So if you're a legitimate co-GP, if you and I are doing a deal together, and we're doing all the work, right? We're searching the market. We're doing the due diligence on the market. We find a property. We're doing our underwriting. Then we do a due diligence. Then we talk to the lawyers. And all the things you need to do. Then you're going to neatly fall into the issue exemption, because there's really 3 things that need to happen for you to fall under this exemption, which everybody falls into. They just don't know that they do, right? That's the issue. Nobody thinks about it. But number 1 is you cannot get paid transaction-based compensation, because that's the hallmark of broker-dealer. So again, you and I are legitimate co-sponsors. We're doing all the work. We're not getting paid because we're raising money. We're getting paid because we found a deal. We're putting this deal together, and we're going to make a lot of money for our investors. Number 2, we have to have substantial duties. Well, yeah, if you and I are doing it, we're doing all the work. So that's not a problem. And then our primary role needs to be doing those substantial duties, which is true. We're doing all the work. Yeah, we have to raise capital, but that's one of 100 things we do. And we do everything else, right? So that's why the co-GP, me and you, not a problem. I fit into the issue exemption. The next layer out, though, which is really the problem that we're having now, is that people are just literally trying to go become a co-GP, like the 3rd or 4th or 5th, or sometimes the 12th or the 15th co-GP. And really, they're primarily there to raise the capital.
But okay, let me just pause you right there and ask one more. There is another exemption, isn't there? If you're an employee of the GP. So the GP can have a W-2 employee, the general partner, who is the investor relations person. That person can solicit from investors, can't they?
Just because you're an employee, there's no special rule. In fact, the statute even says the employee is an associated person. So you still have to run through that analysis. Now, a true investor relations person, you could make the argument, and I've been hearing some folks, again, to the point about where did you hear it? I don't know what the source is. So my guess is my guess is it came from one of these seminars where sometimes the staff shows up and they say, hey, this is not the opinion of the staff of the SEC, but it's my own opinion. But some of my colleagues have been saying that purely being an investor relations may not be enough. But it just depends on how the investor relation works. But just because somebody's an employee by definition doesn't exempt you. There's no, you just make me an employee and I'm good. Investor relations needs to still show that they didn't receive transaction-based compensation, that they did substantial duty. So the argument would be, hey, investor relations is substantial enough. And then my primary role in the deal was the investor relations. It wasn't raising the capital. So if I can fit into those three, that's how an investor relations person gets kind of within the issue exemption. But remember, there are investor relations people and there are investor relations people, right? Some of them are literally not doing anything and they're just taking an email from the lead GP and forwarding it or whatever. That's not going to cut it. But then there are other investor relations that are preparing the business plans, and then any question that comes from the investor, they're the main contact between them and the investors. And literally that's all the person you know is this individual. And I've got a lot of clients that have a really good investor relations person, and that's definitely enough.
And that person is, the point is that that person is saying, please invest in this deal.
Correct, but they are performing substantial duties,
right,
and they are not getting paid a commission. Like you couldn't get paid a commission. Like people want to bonus their employees and say, hey, if you can raise $1 million when you're on the phone, then I'll give you a bonus based on how much you raise. That would be transaction based and you'd be done. Like
you cannot do that.
Yeah, you cannot do that. The employee would have to have a salary. And, this is incidental to their, they're picking up the phone and dialing for dollars is incidental to whatever else they're doing, because their primary role, and to me, primary just means 50% plus one. Their primary role is doing those substantial duties, those investor relations things, or whatever else you're, claiming and actually proving that you've done.
So then there's this kind of workaround that people are trying to do. You were just about talking about that.
And so the workaround, which I agree with, it's just, again, there's other issues, but what's happening, and it's just fun it's fun, or maybe fun's not the right word, interesting to see the progression.
Interesting to see how people think.
Or fascinating to see the progression. So what's happened is I was literally seeing sponsor teams that had like 12, 15, 18 people. And I'm like, there's no way you need 18 people to run a deal. Like you're watering down your returns anyway, and you don't need more than 3 or 4, maybe 5 tops.
So but these guys are just all conduits to cash, and this is
conduits. That's exactly right. And the part that everyone forgets, and I want to point to that as a little bit of a nerdy legal thing, but all those emails that go back and forth, right? Hey, I can bring in this much if you give me this much. No, I'm not going to give you this much. I'm going to give you that much. Yeah, but what if all those emails? They're
evidence.
They're not privileged. They're evidence. And so if there's an investigation, I've seen spreadsheets. I've seen underwriting spreadsheets that have a little box that says capital raiser 5%. Right? That's not a privileged document. So if you argue later, your attorney tries to say, no, this person wasn't brought in to raise capital. They were brought in to do X, Y, Z, and D. And then you're gonna be like, yeah, but this spreadsheet clearly shows that you're getting 5%. Or look at the emails. I mean, let's face it, there are, unless if you were really smart, you'd be like the mafia and you'd be having one-on-one conversations,
walking down the street, walking down a noisy street.
Yeah. But at the very least have a phone call. But I guarantee you these are all emails and DMs and all that stuff. So anyways, that's a side note. So what people started to do is do this, what we call a fund of funds model, like a feeder fund model, which is pretty prevalent in the private equity world. So it's not a foreign concept where if you are really good at raising capital, right? One of the ways you can do that without getting a broker deal license is create your own fund, right? Do it properly, hire a securities attorney, do a PPM, find the right exemption, and raise capital into a fund legally, and then go invest in other people's deals. Like, okay, Adam, you've got a syndication and you need to raise a couple million. Well, hey, I've got a $2 million fund. Let me allocate 500 grand into your deal. And then I go over here to Mauricio and hey, I like your deal too. And so you're really, though, to be clear, you're not technically getting paid to go raise a bunch of money. You're getting paid to do what? That Adam, look at his operations, look at the deal, underwrite the deal, and make sure he's comfortable and get that relationship and do all that work that my investors don't have time to do. So I'm adding value to my investors, and that's really what I'm getting paid for. And then obviously I got to keep my investors up to date, and I got to do the tax returns. All that work is really what I'm getting paid for.
Yeah, but there are some other restrictions on it. First of all,
yeah. So the challenge that everybody forgets or neatly forgets is that, when you do that, there's a very subtle difference, especially in our real estate world, because we're not used to this in the real estate world. It's less of an issue in the private equity world because it already is. But when you invest in real estate, you don't need any special license, right? I'm just going to go buy a property. There's nothing magical that I need. I can have zero education. I can go buy a piece of property. But when you invest in somebody else's deal, what are you doing? You're buying shares in their company, LLC units, really, but you're buying a piece of the company. You're buying a security at that point. So now the government says, wait a minute now you're advising your fund as to the purchase of securities, not as to the purchase of real estate. Now you're buying securities, which makes you an investment advisor.
Mhm.
Right. So now you got to decide, okay, what does that mean? I'm now an investment advisor. Does that mean I need to register anywhere? Do I need to go get a license somewhere? And the answer is generally no, because for most of us, it's a state by state issue. Anything less than $150 million will be at the state level. And so most of my clients are raising at most 20, 30, maybe 40 million. So they haven't gotten there yet. And so I have to look at the state, and not every state, but I don't know what the exact number is, probably 46, 47 states out of the 50 have some sort of an exemption to registration, to getting that license. It just depends on how onerous the terms are of that exemption, right? So some states like Pennsylvania, for some reason, Pennsylvania comes up because I have a lot of clients in Pennsylvania. Pennsylvania basically doesn't care. They're like, look, as long as you don't do more than 5 or 15, I forget now, of these funds, and you don't hold yourself out to be an investment advisor, you're good. You're going to have this exemption, right? Then you move over to states like Texas, which is like, yeah, we don't really care. You don't have to register as an investment advisor. However, we're going to limit you to only accepting accredited investors only. So that's going to be your limitation. And we're going to require you to file a little truncated ADV form just so we know what's going on. Okay, great. Then you move, for some reason you're moving west, but then you move to sort of the outside. It's not just west. So Washington comes to mind. Actually, Washington is the worst. Massachusetts, I got somebody today from Massachusetts. So Massachusetts, and actually California to some extent too, but Massachusetts says, yeah, you can get an exemption. However, all of your investors must be qualified clients, which means they have to have $2 million in net worth. Forget the $1 million. They have to have $2 million in net worth. I'm like, wow, okay, that's really difficult. And then you have states like Washington that requires the qualified, like institutional level stuff, where you have to have $5 million of investable assets. You have to limit your clients to those. So obviously in those states, for my clients,
But then you're also limited to 99 members in the LLC, aren't you?
that's another thing. Yeah, that's another option. So we're just talking about investment advisory. So that's one level of analysis that we kind of just went through. The other thing that you, like, to your point, is we have another statute out there called the Investment Companies Act. Yeah. And that's another thing that only applies when you're buying securities. And the Investment Companies Act, you don't want to become an investment company, because then you've got a bunch of other regulations. And so you want an exemption. And the easiest exemption is it's called a 3C1 exemption, which says as long as you have less than 100 investors, right? Then you're not going to fall under the investment company. So most of my clients will rely on that, but you got to be careful, because if there's 3 or 4 sponsors, they count as members, so now you're down to 96. And then if you have an LLC as one of your investors, and that LLC has a bunch of members, so you got to be a little bit careful. But yes, that's the easiest way to get around that statute. And then the last thing you got to worry about, I believe, is you still can't
compensation.
You still can't have be a broker dealer. And so if you just created some smoke and mirror scheme where I'm just raising a bunch of money into my entity and I'm giving it to you, and it's just at the end of the day, it's kind of a disguised commission. That's another concern. So you really want to be able to show that you're actually adding some value to your investors, and that's what justifies whatever cut you're getting of the deal.
And then you also have to be careful where you take your compensation from, don't you? If you're raising money, you still can't. It's better to take your compensation from the investors, to say, look, here are the fees. If you charge your there's these investors, they pay those fees.
I think where you're going to, so that's a great point. So when you raise capital into your own fund, and let's say I invest into your deal, Adam. So I say I'm going to allocate $1 million into your deal. I now become literally a limited partner in your deal, right? And the way I really get compensated is by basically negotiating with you and saying, Adam, like, I'm going to bring in $1 million, dude. I don't want the 8% that you're giving all the other people. I want 10%, or I want 12%, or I want something better, because I'm bringing a big chunk of dough. You only have to deal with one person. You don't have to deal with 100 investors. So you're going to give me a better return. And so my fund will receive that better return. And from that excess cash, that's really where I'm going to start digging into my cut. What you don't want to have happen is take a direct payment from the underlying sponsor to my pocket, because then that's looking like a broker-dealer transaction too. So it's got to go through the fund, because that's how, at the end of the day, that's what you're doing. You're just investing in somebody else's deal. You're a limited partner. Your revenue is going to be the distributions that I get from the underlying deal. And then from that pool of capital, I'm going to split it with my investors 80, 20, 90, 10. I'll take.
And you can have, so I've seen these where basically you have 2 layers, 2 promote layers. where the fund of fund has its own promote, and then that sits on top of the
Yeah, so you do. That's why you've got to negotiate better terms because otherwise you start getting a little bit diluted, right? So like,
diluting all the investors. Exactly.
yeah, and so like at some point it's like, well, wait a minute, why am I investing through your fund? I could just go straight to Adam and I'm gonna get a better return. And so you
Right.
got to be careful about that too. But yeah, and again, as long as everything's disclosed, there's nothing wrong with saying I'm going to charge an acquisition fee, but we're also kind of getting charged an acquisition fee down there. As long disclosure is the name of the game.
It
So as
is,
long as
isn't
we're
it?
getting disclosed, you can do whatever you want.
Yeah.
That's why you just want to have a good securities attorney to make sure that they understand that and they're disclosing everything, no matter how crazy it looks. It doesn't matter. Like if you, I always joke, I say, hey, look, if you want to take 99% of the profits, like knock yourself out. You can do that. Nobody's going to invest in your deal. But if you wanted to take 99% of the profits, as long as we disclose that in the documents, you're good to go.
So you've described seeing sponsors with dozens of
Oh
co-GPs.
my goodness. Yeah.
I have actually not seen that, but what I have seen is individuals who are co-GPs in dozens of deals.
Oh, yeah, 100%. That happens all the time. And I'm glad you brought that up because I think that's also a factor when you're trying to figure out, hey, are you doing substantial duties or do you fit under this issue exemption? There's a big difference between, a group of 2 or 3 people that are part of a real company. They're all under the brand and we do 5 or 6 deals together. That's because that's our company. That's one scenario. The other scenario is, like you said, there's one person and I do 6 different deals with 6 different GP teams. The scrutiny, I think, is going to be much more on that person because it's like, okay, why are they skipping from GP team to GP team? Is it possible that I'm doing substantial duties for all of them? Of course. But I think the scrutiny is going to be much higher and your burden is going to be much higher to show that you're really doing stuff versus, some of my clients that just have a legit, real estate company and they just have 4, 5, 6, 7 partners inside and maybe not even partners. They're like, oh, it's the investor relations person. It's the acquisitions person. It's like a team that
Right.
always does the same stuff. But I do think that's a factor when it comes to the compliance and the burden of proof, so to speak.
Okay, so these are hard concepts to understand actually. And the only time that people really learn them, unfortunately, is when the proverbials hit the fan. I should temper my language.
Yes.
So here's my question about this. It's been going on for years. You and I are talking about this.
Yep.
As though it were commonplace, which unfortunately it is.
Mm-hmm.
So how is that possible? And the question I have for you is enforcement. To what extent are these, when you talk about laws, that's great, but if no one enforces them, who cares?
100%. 100%. But here's the challenge. So usually enforcement happens when people start losing their money. The SEC and the state, it's really more a state regulator that you really should be more worried about than the SEC. So some states are more crazy than others, but they're not scanning the web. They're not picking up the phone and interview. Like they don't have time for that. They come into action when they get a call from a disgruntled investor that pick up the phone and say, hey, this person, I lost their money and I think they're doing something, I think whatever. And they make a complaint. That's when the audit process starts. That's when the regulator reaches out to the sponsor and requests all the documents and they start doing their investigation. Look, for the last, since when? Since 2009, 2010, we've had nothing but, green pastures, right? And everything's been just been fine. Yeah, we had a little bit of a dip during COVID, which we thought was going to maybe be the beginning of the end. And it turned out to be the opposite. It's like we had a little bit of a dip and then the top blew off. But, since 2021, things have not only leveled off, but, multifamily is in the decline. Not since then. It really just declined about 20-25% back then. And since then, it's kind of stabilized. But if you're one of these syndicators that bought in 2020 or 2021, when interest rates were at 4%, when, valuations for frothy, it's going to take a little bit of time, but you're already seeing people, losing their properties to foreclosures, investors being upset. And so it's just a process that's going to go through, but I do expect more and more complaints to happen. Remember, people have, a couple of years to file lawsuits and, for the SEC to get involved, but it's going to be investor lawsuits that are going to trigger this.
Right.
And the problem is once it's out of the bag, you can't put it back in the bag. So if suddenly there was a big announcement and now that you suddenly hear the SEC is suddenly cracking down on this stuff and you're going to be like, oh crap, like I already did it. Like there's nothing I can do to unwind it. I can stop doing it moving forward. But if I did this 2 years ago and I, raised capital for someone and I've got an unlicensed brokerage or I'm doing this stuff wrong, there's nothing I can do. I'm just like at the whim of just waiting for the SEC to catch up with me or an investor to really.
Right. And the jeopardy is like this. So you can put together a set of offering documents or a sponsor can that is highly protective of their position relative to their investors, right? It's like a lot of exclusions, no voting rights, whatever. It's very protective of the sponsor.
Yes.
And these are as is contracts. So if you don't like the contract, sign them or don't invest.
Correct.
But which is an incredible wall of protection. But the crack in the wall is fraud. So if an investor calls their attorney and they say litigate and says, look, I invested with this guy, but he had an unregistered broker dealer who brought me in, that whole defense collapses, doesn't it, Mauricio?
Yeah. So I've been talking about this a lot too. So there's really two things when you're doing the syndication, there's two parts of it, right? One is the raising capital part, right? And that's the concern that you could have, but that happens at the point of sale. That's why I said it already happened. So once you sell that, once you take the investor's money, did you provide all of the relevant material facts and disclosures at that time? Now, we may not realize until later that you didn't, but that we're looking at it at that point. Once you close on the property, then in addition to, or hopefully you did the securities part okay, and you had a good securities attorney, but now you're running a business and you have fiduciary responsibilities to your investors, and you need to act as a reasonable, prudent syndicator would under the same or similar circumstances. And if you fall below that standard, then that's an issue. But so, for example, rate caps is a good example. It's like I'm actually right now trying to figure out what everybody was doing back in 2021 regarding rate caps. Like how much were they getting? How long were they getting? Because again, you may have lost everybody's money because interest rates went too high and your rate caps weren't good enough. But if the industry standard said you get a 2%, cushion, and that's what you did, you're probably okay. However, if you didn't do the securities part right, you could be fine on that. I'm fine. I didn't lose. I'm not responsible for you losing money because I did what I was supposed to do and I acted reasonably.
Right.
But, oh crap, I didn't disclose something or I acted as an unlicensed broker.
Right.
Then you're going to lose on that end. And remember,
that's the point I'm making.
With
right?
unlicensed brokers, it's both sides. So the person who's raising the money, right, who's bringing it in, they're acting as an unlicensed broker. So they've got liability, which is usually disgorgement and penalties and fees and things like that. But then the sponsor failed to disclose, because why would you? But they failed to disclose that they were making a payment to an unlicensed broker dealer. Right. So you're not disclosed. So that's what they're going to get you for failure to disclose. And they're going to say, hey, had I known that this person was getting paid and was a broker, I wouldn't have invested. And that's why I lost my money and blah, blah, blah.
And then there's rights of rescission. And this gets really
That's
messy.
the main one. I got that ebook, as you know, the 5 things every syndicator must know to stay out of jail. But you're right. Unless you're doing fraud, Bernie Madoff kind of stuff, that's where you end up in jail. But the normal, the more common is a right of rescission. So you have to return all of your investors' money back, plus interest, plus you're going to be banned from raising capital for whatever you negotiate with the regulator. Like, is it a couple of years? Is it life or whatever it is? And most likely, you've lost investor money. You probably don't have the money to give it back. So you're going to file for bankruptcy and you're pretty much done raising capital ever again, if that's the scenario that you raise. So it's still a pretty serious thing. And that's why I know I picked that title. It's a little bit maybe over the top, but the reason I picked that kind of over the top title is because I felt like, and I still do, that people aren't taking the securities laws serious enough. They're like, oh, everybody's doing this or whatever. Like, we're going to make a bunch of money anyway. Who cares? And I really wanted to emphasize the point that there are, first of all, securities is a complicated matter and it's convoluted, but there are some serious consequences and you should pay attention. And just because everybody else is doing it, first of all, not everybody else is doing it. Usually in your world, everybody else is doing it. There's still, most people are doing it right.
Before we move on to the next topic, I want to talk to you about marketing, which is something you and I have been chatting about.
Yeah.
But before we move on to that, so here we are. It is March 24. So what prevalence do you think this is? Like, how big of a problem do you think this is? This unregistered, this kind of the term you used was don't blow your exemption by paying capital raise. Like everything we've just been talking about, how prevalent, how serious is that going to be, do you think, in terms of the unraveling of the market?
I do believe, and I granted, maybe I've had the timing wrong because I've got some videos from like 2020 where I've been saying this. So it's been it's like I feel like I'm. Never mind.
Nobody ever pays attention until it actually happens.
Yeah, and I kind of
like Cassandra. She always spoke. Cassandra was cursed with telling the truth and never being believed.
That's right. That's
That was
right.
her curse.
I do have some videos in the past, but I almost want to do some new videos so that I can then do the Gary V thing where he puts the side by side and say, this is from like 6 years ago, and then hey, this is an article that just happened.
Right,
I
when you
do
had
believe it's
black hair. That's when you
I
had.
believe it's gonna. Yes, exactly. I definitely have black hair. I do think it's gonna unravel because I think people are already starting to lose money, but we're not
Yeah.
quite there yet. We're in the point where people are doing cash calls, and then some people are. Some properties are going into foreclosure, and we've read about those. But we were just
How
looking
much
at
do
a
you think
stat,
is under the surface,
a
Maurice?
lot because all of these. Remember, as you know, back in 2020, 2021, that's when the bridge loans started coming to fruition because getting a traditional loan, a Freddie and Fannie, they would only loan you 60, 70, not even 70, like 655, 60, maybe 65% loan to value. And so the numbers didn't jibe. Because the prices were going up so high, but the rents weren't keeping up. So the debt coverage service wasn't being met. And so people started switching to these bridge loans, these 3-year bridge loans. Everybody thought there were 5. They were saying, oh, it's a 3 plus 1 plus 1, but they were really 3-year loans.
Mhm.
And now the idea was, oh, in 3 years we'll refinance, we'll do this, we'll do it, whatever, we'll sell or whatever. But now those 3 years are starting to expire, and we're in the middle of it. Like they're starting to expire in 2023, 2024, 2025. And there's just nowhere to go. You can't sell it without a loss, and no bank's going to refinance. There's nothing there. And so equity is kind of, wiped out, but it's a process. It's got to unravel. It's going to take its time. But I think here in the next, couple of years, as these things become bigger and bigger, and then remember, you have a time, you don't have to sue the minute it happens. Like if I lost all my money today, I don't have to file a lawsuit. I've got to look for a lawyer. The lawyer has to look at the deal and they maybe do a class action. I mean, there's several steps. So it's a process. It takes years for these things to unravel. But when they do, it's like a slow, what is that? The snowball effect. Like once it starts moving, it's just like, it doesn't stop. So I do believe unless you get some miraculous, which I think most people the people who are in trouble are hoping for, some miraculous U-turn where suddenly rates fall to zero and somehow lending is available. I think we're in for a rough spot.
Yeah.
But I love people have been talking about this, and I have talked a little bit about it because Ken McElroy talks about this a lot, where it's not necessarily a lot of my clients do multifamily. It's not necessarily multifamily or apartments in general that are the problem because they're actually doing pretty well, right? The rents are pretty strong, occupancies are pretty strong. It's the syndication business that's really struggling because people got kind of, way over their heads in terms of the loan product and getting, interest. The deal only worked at 4% interest rates. Well, now we're at 7 or 8, and there's just no way this deal survives on those kind of numbers.
Let's move on to the next topic. Marketing. Let's have a look at the timer. So I forget when we started, but anyway, let's just do this. It's a good topic, and it's your second question. No, your second. The second of 7. We're no way we're going to get through all of these. But the second one I want to talk about. This is a really cool one, actually. I'm going to read this. One of your posts again.
Okay.
Read it to you. It's very cool because it totally speaks to what you and I have been talking about. Quote. Although posting content on you and your company is something that the SEC allows, it needs to be consistent. Far too often, I see syndicators never post on social media, but a week before their offering starts, they're all over social media and there's a spike in activity and all those posts are going out. And then once the syndication is over, they no longer post. Okay. My comment here. Oh, no, you wrote this can be a red flag for regulators. That's interesting. So my question is, why is it a red flag? My thought when I first read was that's a dreadful thing to do for any kind of marketing. You don't just immediately show up and say, here, invest now. You want to be talking, nurturing, developing a relationship. Why is it a red flag for regulators?
Yeah, and by the way, when we talk about those posts, we're not talking about, and again, let me just backtrack a bit. We're talking about deals that are relying on an exemption that does not allow advertising. So we're talking about 506B deals.
Oh, that's
right? So
what
if you're doing a 506C, knock yourself out. But in a 506B deal, you're not allowed to generally solicit or advertise. But what the SEC does allow you to do, they recognize that you have a business to run. So posting about yourself or your business, that
That you
doesn't
can
mean
do.
posting about the investment. It means, hey, for
Ah,
example, my favorite ones are, hey, check out the status of our pool. Like, we bought this property last year. Look at the pictures of the pool. It was awful. And we went in there and we dug in. Look at the renovated pool. Look how pretty it looks. Those kind of posts. Or, hey, look at this kitchen that when I bought it, we renovated the kitchen.
I see.
Or, hey, we just, we whatever, we just sold a property. It's about your business in general, or about you. Like, hey, I'm a real estate, I love multifamily, and this is why I love it. And this is what we
Right.
specialize in. Those are the types of posts that are allowed under a 506B. Under 506C, you are allowed to advertise
Do
and
anything.
solicit. So your comment is more whether that's good practice or not from a
Okay, I
marketing
get.
standpoint. I don't know, but yeah.
So I just see the distinction. Okay,
Yeah.
so that's interesting. So this is 506B, and the point you're making is 506B, you can't solicit.
Correct.
But the red flag is if you suddenly show up talking about yourself for 2 weeks before
Right.
a
Right.
launch, and then you disappear. And
Yeah.
that's because that's tantamount to soliciting.
It's kind of there's a term of art which is very nebulous, which is why I generally recommend staying off social media if you're doing a 506B and you're in the middle of a raise. It's something called conditioning the market, because that the definition of an offer, which the SEC regulates, it not only includes sales of securities but the offers of securities. And when you condition the market, when you start saying things that really get people excited, and it's like, look at my past returns, or I triple digit returns and I'll triple your money, and that could be considered conditioning the market. Now, honestly, it's subjective. So, I mean, I can argue anything can be the thing. And so that's a concern, is that what I've seen generally is people don't ever post anything. And then literally a week before they start posting, and they can't help themselves. I mean, I literally do screenshots of these posts for when I do presentations, and I obviously blur everything out, but they literally can't help themselves. So somewhere in that post, it's, hey, if you're interested, reach out to me, or hey, if you want to learn more, click on this link, or hashtag invest with me, or whatever it is in that post, which is they just can't help themselves. So generally speaking, if you want to talk about, like I said, that I saw one of my clients in a nice job the other day. They were like, hey, we're here at a 600 unit apartment building, and we're going to do a walkthrough, and we're going to show you what the things we look for. And so I always think, I know you like checklists. Here's my checklist of the 5 things you want to look at when you're doing your due diligence or walk through a property. Look at the parking garages and the parking, and look how the things, when we go into the rooms and the units, look at the cabinets, or you look at here or look at there, whatever it is that you're looking at. That's you're not talking about an investment per se, or hey, come invest in me. We're talking about basically that when I'm educating you on how to go about doing doing a walkthrough. But you want to be talking about your business, not your investment part of the business, but your actual business. So that's why I like those before and after pictures, or hey, we just hired somebody we just hired a new acquisition person, or we just finished renovating. Just talking about it's almost like a resume. It's not super exciting, but it's talking about your resume, because the real way to do it, which is the way I think you and I both agree on, is to add value, right? So adding value to your avatar, not talking about a deal, but talking about being a thought leader and letting people know that you know what you're talking about. And this is why we love multifamily, or this is why we like mobile home parks, and this is why we like Florida, or this is what the things I do, and this is how we turn the property around. And those are the kind of posts that I really like, usually when you don't have a deal, so that you can use social media to show people that you know what you're talking about, get them into your world, and start that process.
So I just had a wacky idea for what we
Yes.
can do together on an event on LinkedIn.
Perfect.
I'll share that with you as soon as we finish up here.
All right, sounds good.
Teaser for everyone listening. You might be really too wacky, but it's an interesting idea. And let me ask you this then. Let's just have a look at the time. Let's not go too much longer. But so do many people do Reg 506Bs anymore? Why would you even bother? Why would anybody?
I know, it's fun. It's
so restricted. It's so easy to do a C. Yeah, you got to get accredited. Reasonable steps to verify accredit. Big deal. It's no big deal. It's, $10 you pay to verify investor. Nobody complains about that. You can't take on non-accredited investors. Okay. Bummer. Right. But so why do people do Bs anymore?
So if you look at the SEC data, which is the Form D filings, between B and C, 92% of deals are 506B deals, and only 8% are 506C. Now, those numbers are a little skewed, and I'll tell you why. The vast majority of those are huge institutional, like Merrill Lynch,
$20 billion,
and they use broker dealers. Like, Blackstone has, I think now it's a $50 billion fund, right? That's a 506B. Now, they only take accredited investors, but they have relationships with all their investors through their broker dealers, right? So it's a little bit misleading. But in my practice, I'm going to say 2/3 to 3/4 of our deals are 506B and about 25 or 30% are 506C. And it's primarily because when you're, and we deal with a lot of new syndicate, when you're new into this business,
Yeah.
you want to have Uncle Bob and Aunt Karen and your mom and like an event inevitably
Non-event, you mean
non-accredited. Yeah.
non-accredited?
And so the first couple of deals
Oh,
tend
I
to be
see.
a 506B. And then when you run out of that network or you run out of capital, then you start opening it up a little bit. But as you know, Adam, 506C, everybody thinks, oh, it's a 506C. I'll just start posting on social media and I'll fill my, I'll fill my offering because I'm going to make a couple of posts on social media. And as you know, it takes a long time and there's a process that you need to run people through. It's not a question of just, I'm going to throw a couple of ads and say, let people know I've got a fund open and I'm suddenly going to fill it. I mean,
Right.
it's not as easy as that.
With the wiring instructions and
Right.
just,
It's not as
wait
easy.
until
Yeah.
the end of the weekend.
Yeah.
It's going to be.
And I have heard, because I'll tell you what, one of my well-known clients who has a huge audience and he still does 506Bs and he only takes accredited. So that's the real question. It's like, wait a minute, if you're already just taking accredited only anyway, why wouldn't you do a 506C? Because then you can blast it to your YouTube channel, to your podcast, to your whatever. And the pushback has always been, look, high net worth individual. I'd love your take on this. They're like, hey, look, if I'm a high net worth individual and I'm looking at 10 deals and 8 of them don't require me to share all my financials and 2 of them do, all things being equal, I'm going to go over here. I don't necessarily buy that because it's not, like, to your point, it's not that difficult to verify. There's a lot of these companies out there that you don't even show your financials to the sponsor. You show them to a third party attorney or a thing. But that seems to be the concern of people who don't want to move to 506C. But if you have an audience,
Yeah,
I think there's just
Mauricio,
more
I'll tell you something.
reason.
I think that concern that people won't invest because they got to share their financials to prove that they're accredited is more of a concern of the sponsors than it is
Yeah,
actually their
could be.
investors. Their investors
Could
don't
be.
care. If they're going to invest, one of the biggest challenges is people that have been in the business for decades and have hundreds of investors that have been with them for decades. And suddenly they do a 506C and for the first time they got to say, listen, sorry, you got to prove that you got to send me something to prove you're accredited. Okay, so that can be a little bit awkward, but I've seen people work around that as well. Let me ask you one last question on the same topic. 506B doesn't allow you general solicitation. It does, however, allow for solicitation to pre-existing relationships. And you wrote a very interesting article, actually listed it out in graphic detail. But what is, like, has that ever been actually tested?
Yeah, so that one I have a source. So
that one I do actually have a source for. Okay.
So most of the SEC stuff is very nebulous. It's very vague, right? What is an offer? Oh, condition the market. What does that mean? You'd think there'd be a nice definition of advertising in general. That there's no definition of what advertising even is, right? But when it comes to determining whether you have a pre-existing substantive relationship, there is actually an SEC no action letter. A no action letter, we don't need to get detail, but there's a no action letter that actually spells out, hey, if you do these 8 steps, I don't think they call it 8 steps, but I counted them and there's like 8 steps that they listed. So if you do these 8 steps, we think you would have done a good enough job to show that, because you've got to prove it. You got to document it. And so that's where this thing comes. There's a no action letter. You can Google it. It's called Citizen VC, no action letter. And it spells out, the Citizen VC said, hey, SEC, here's what we're thinking about doing. We have a website that's going to be password protected. And these are the steps and these are the policies we're going to have. If we do this, SEC, are we good or are we not? And the SEC, look, if you do this, then you're good. Now, legally, that only applies to Citizen VC, but it was kind of a roadmap for us to tell us what the SEC was thinking of. And I think the most important part of that no action letter was this concept that the SEC was very clear that they didn't believe in the 3-touch rule or the 30-day waiting period. A lot of you hear that a lot of times. They were more interested with the quality of the interactions between the prospective investor and the sponsor. They wanted to see that fostering of the reaction. So there was no magical timeline. I've always argued that you could spend, you could go over, because we've done this. We go overseas with a bunch of investors and you literally spend 72 hours nonstop, breakfast, lunch, and dinner. You get to know them really well. That might be enough to do a substantive relationship, versus you might be on your email list for 5 years, but it's like you're just dripping them once a whatever. That's not going to count either. So it really is the quality of the interaction. It's having a phone call with them. It's having a questionnaire that they fill out so they can tell you, hey, here's my level of experience. I'm conservative. I want to swing for the fences. I'm cash flow. I'm appreciation. Like all those kind of questions that you would usually see when you're getting a margin account or an options account. Uh, but the SEC just enumerated them. So I'm like, well, let's just go thing. The only one that most people don't do is that the SEC, part of those 8 steps were getting a credit report from the prospect. So you can kind of, number one, see if there's any liabilities. Obviously, you're trying to figure out their net worth. And so let's see how many liabilities there are. That might show them on a credit report. And also just to prove identity and all that stuff. Honestly, most people aren't going to do that. But the closer you can get to those 8 steps, the closer you are to being able to argue that you do, in fact, have a substantive relationship with your investor. And then once that happens, you document that date. Like if today's the day, I can only offer them a future deal, right? So if I'm already in the middle of a deal, I can't offer you that deal just because today we became a substantive relationship, because I have to have a pre-existing substantive relationship. And that means pre-existing the deals, pre-existing the offering. And so once your offering starts, and that could be obviously also, very nebulous, but once the offering starts, anybody that you meet after that, it's impossible for you to have a pre-existing substantive relationship with that new person, because the offering's already started. You can have a substantive relationship with that person, but that would never be pre-existing. So you can only offer them a future deal.
Credit report's interesting because as soon as you actually do take money, you got to run AML and KYC and through FAC anyway. So you're doing some pretty deep. I mean, the banks require. All right, there's different all sets of regulations to figure that stuff out.
Yeah.
Mauricio Rauld. Am I pronouncing that right?
Yeah, sure. Well, it's funny. A quick story. Like my last name is French, and so if the French pronunciation is nowhere near from the Spanish pronunciation, which is nowhere near the English pronunciation. But I go with Rauld. Yep, Mauricio Rauld.
Okay, Rauld. Mauricio Rauld, Esquire, Premier Law Group,
or JD as well, Juris Doctorate.
JD Esquire. Premier Law Group. Thank you so very much for joining me.
Thanks, Adam. Thanks for having me. Appreciate it.
All right, that was Mauricio Rauld, Esquire, talking about some of the key things that you really need to be keeping in mind if you're a syndicator, but also if you are an investor, to make sure that your syndicators or the people you're investing in are playing by the rules. Oh my goodness me, being a rule follower myself, I find this stuff really interesting and really critically important to see that this is what's being done. Just from, if nothing else, an integrity perspective. Anyway, that's it. Mauricio, what a pleasure to meet you today. Thanks so much. I really enjoyed our conversations. Let's stay in touch for sure. And thank you as well, dear viewers. I really appreciate you being here today. This show would be nothing without you. And I have to remind you, please do go to GowerCrowd.com. If you're not on our newsletter list, go ahead, sign up there. It's totally free. Educational content once a week with news updates covering the world of commercial real estate, syndication, and crowdfunding. That is also actually a lot of fun to put together. And we get incredibly high open rates. I think it's largely appreciated, even if I say so myself. All there at GowerCrowd.com. That is all I have for you this week. Until next time, Adam Gower signing off.